Hello friends, very warm welcome to my business laws channel. Friend, this will be the third chapter to the special contracts. In my earlier videos, I have covered first two chapters to the special contracts. First chapter was contract of indemnity and guarantee. Second was contract of bailment and pledge. So this is the last chapter to special contracts in which I will cover contract of agency. Let us start the meaning of contract of agency, where a person employs another person to do any act for him or to represent him in dealing with the third persons so as to bind himself by the act of such another person. This is known as the contract of agency. It has been defined under section 182 of the ICA 1872. Such another person is known as agent, and the person who is so represented is known as the principal. Friends, remember the law relating to agency is contained in sections 182 to 238 of ICA 1872. Now let us talk about two principles upon which the contract of agency is based. So friends, the very first principle is whatever a person competent to contract may do himself, he may do through an agent, except for acts involving personal skill and qualifications. Any contract, any act which involves personal skill and qualifications, only that can be undertaken by the principal himself. Leaving all these other acts can be assigned to the agent. So, but friends, now the question arises, which are the acts which involve personal skill and qualification? Say, for example, friends, principal has to do LLB or the principal has to marry. Then, these acts cannot be assigned to the agent. So, friends, leaving this, any other act can be assigned to the agent. Let us talk about second principle. Second principle is, friends, he who does through another does by himself. It means, friends, the acts of the agent are for all legal purposes the acts of the principal. All the acts of the agent are the acts of the principal. Because in the eyes of law, agent and principal are the same person. The act is done by the agent within the authority. Then principal will be liable for that. So friends, I have explained both the principles upon which the contract of agency is based. Moving ahead, friends, let us talk about features of contract of agency. What is contract of agency? Contract of agency is the agreement between the principal and the agent. Competency of the principal. Principal must be competent to contract. It is must, friends, on the part of principal that he must be competent to contract. Competency is not required for an agent. Agent may be competent to contract or may not be competent to contract. Friends, if you remember, we do talk about minor agent. Any minor who is not competent to contract, he can be appointed as an agent. Okay, so competency is must for the principal, but it is not required for an agent. Coming to the next point, which is contractual relationship. There is contractual relationship between the principal and the agent. Agent goes and acts on behalf of the principal with the third party. But it is the principal who is held liable for all the acts of the agent towards the third parties. Creation of legal relations. Agent creates the legal relations between the principal and the third party. Consideration not required. No separate consideration is required when the contract of agency is created. Nothing new, friends. I have already covered this point under the exceptions to the contract. No consideration, no contract. So exceptions to the rule of no consideration, no contract. Fifth point was contract of agency. So in case of contract of agency, the moment contract of agency is created, then separate consideration is not required. But still, friends, the contract of agency is valid. The last point is intention of the person to act. Agent should have the intention to act on behalf of the principal. So this is all about the various features or essentials of contract of agency. Now friends, I would like to talk about kinds of agents or classification of agents. Now on the basis of extent of authority, they can be classified into 3 categories. The very first point is, friends, general agent. Second is special agent. Third is universal agent. So friends, who is general agent? As it is clear from the term itself, he is one who is employed to do all acts connected with the particular business or employment. See, principal has got leather business, and all the acts relating to that business he wants to assign to the agent A person. So A will be known as general agent. Special agent, he is one who is employed to do particular act or to represent his principal in some particular transaction. See, the principal wants to buy, Wagoner car for his personal use. And he is so busy, he appoints a person as his agent. He says, you go and go to the showroom and see all the cars and then select, the car as per my requirement. An agent goes to the car showroom and he selects the car which suits the purpose of his principal. Here, friends, A will be known as special agent. Coming to the third category, universal agent. Universal is universal, as it is clear from the name itself. Whatever authority is assigned by the principal to the agent, the same task has to be done by him. Okay, he enjoys maximum authority. He is authorized to do all the acts which the principal can lawfully do or can delegate. So friends, maximum authority is exercised by the universal agent. Say whatever task is given to him by his principal, he will have to do the same. Special agent is always appointed for specific purpose. General agent is appointed, to do all the acts connecting with the particular business or employment. Now, friends, moving ahead, another classification is, mercantile versus non-mercantile agent. Who is mercantile agent? Mercantile agent is one who has authority either to sell goods or buy goods or to raise money on security of goods. He can sell the goods, he can buy the goods, and if the need arises, he can raise money or loan on the basis of security of goods. The various kinds of mercantile agents are factor, commission agent, del-creditor agent, and then broker. Factor is a person, friends, who is given the possession of goods. He can sell the goods, he can buy the goods, he can raise the money if the need arises. Commission agent, any agent who is appointed on commission basis is known as commission agent. So commission agent is not a separate class of agent. Anybody who is appointed on commission basis is known as commission agent. Del-creditor agent. So sometimes, friends, the goods are sold on credit basis. In that case, bad debt may arise. So we will bear the loss of bad debts, principal or seller. But if the agent takes this responsibility that he will bear the loss of bad debts, then he'll be given extra commission for that, which is known as del-creditor commission. And such agent will be known as del-creditor agent. I hope you must have understood this term, which is del-creditor agent. Broker. Broker is also the person. The difference between the broker and the factor is, friends, that broker is not given the possession of goods, but factor is given the possession of goods. Broker is a connecting link between the buyer and the seller. Now coming to the non-mercantile agent, they are advocates, attorneys, insurance agents, and wife is also considered to be an implied agent to her husband. Advocates, they always deal with the legal matters. Attorneys, insurance agents, they buy insurance policy for the insured person. And for that, they act as an agent and they charge commission from the insured person. And wife has a right to pledge the credit of her husband for the purpose of necessities. So she's also considered to be the implied agent to her husband. So friends, this is all about the classification or kinds of agents. Moving ahead, friends, now I'll take up the heading creation of agency. How is the contract of agency created? Contract of agency can be created in 4 ways. Agency by express contract, agency by implied contract, then agency by ratification, and the 4th one is agency by operation of law. Agency by express contract. Being students of mercantile law or business law, you all know, friends, that what is this express concept and implied concept. I've taught you, I've covered in the very first chapter under the heading kinds of contract. Express may be verbal or written. But implied is neither verbal nor written. It is always implied from the conduct of the parties or from the circumstances or relationship of the parties. So when we talk about agency by express agreement, then advocates or lawyers, they use their power of attorney, which is known as POA. Whenever they go and represent their client, then they always use their power of attorney. So that is a very good example of express agreement. Then agreement by implied agency by implied agreement. An agency, I have told you, it is said to be implied when it arises from conduct, circumstances, or relationship of parties. It has got 3 forms. First is agency by estoppel, second is agency by holding out, third is agency by necessity. Now, agency by estoppel, friends. You must have heard, friends, partner by estoppel. Partner by estoppel is not the actual partner of the partnership firm, but whatever he says, he will be bound by that. He is deemed to be a partner of the partnership firm. So agency by estoppel, and in case of partnership, friends, that there is mutual agency element. So agent by estoppel, if principal allows someone to sell his goods on his behalf, and agent is selling the goods, A is selling the goods on behalf of principal, but principal is not objecting to this, then A will be deemed to be the agent of principal by estoppel. Because principal is not objecting. When he has not authorized him, then he should object to this. And if he is not objecting, it means, that agent will be known as agent by estoppel. Second is agency by holding out. Now, friends, let me take the example of partnership. In case of partnership, say partnership firm is consisting of 3 partners, A, B, and C. Out of 3 partners, A was very active partner. He was dealing with the third parties, going to the third parties, getting the goods on credit basis. And once upon a time, he retired from the partnership firm. But partnership firm did not serve any notice to the third parties, saying that A has retired from the partnership firm. A, after his retirement, went to the third party, bought the goods on credit basis as he was buying the goods in the past period. Then in that case, the firm will be liable to make the payment, because notice was not served as to his retirement to the third parties. Once the partnership firm has held out to the third parties that somebody is his partner and that person is not a partner, then in that case, that person will be known as, then the partnership firm should inform the third parties. If the partnership firm doesn't inform the third parties, the firm continues to be liable for the acts of such retiring partner, even if he has retired. Third is agency by necessity. Necessity may arise. Okay, so in that case also, friends, that person will be known as the agent of his principal. Some emergency has taken place. Say, for example, principal wanted to transmit some goods to B of Mumbai to railway authorities. And possession of the goods was given to the railway authorities. And on the way, the railway authorities found that goods are perishing. Then, the railway authorities was trying to contact the principal, but principal was not being contacted. And then, they decided to sell the goods in the best interest of the principal. Here, railway authority will be known as the, agent of the principal by necessity. So friends, I have explained all these forms of implied agreement, agency by estoppel, agency by holding out, and agency by necessity with the help of example. Still friends, if you have any doubt, you can always write in the comment section. I will always clarify. Moving ahead, the next one is agency by ratification. What is ratification? What constitutes ratification? Ratification means subsequent acceptance of an unauthorized act. Section 197 of the Act lays down that ratification may be express or implied. So what is ratification? Subsequent adoption or acceptance of the act, by the principal, which was done by the agent without the prior authority of the principal. Okay, ratification tantamounts to prior authority. Ratification is equal to the prior authority. Ratification is equivalent to the prior authority. Friends, just now I said that ratification is equivalent to the prior authority. No doubt it is equivalent to the prior authority, provided the ratification is valid. And now the question arises, what constitutes valid ratification? Requisites of valid ratification. So the word is, friends, ratification. I would like to correct. The first one is the act must have been done on behalf of the identifiable principal. The principal should have been identified. Third parties should know that who is the principal in this case. Then only the ratification will be valid. The principal must be in existence at the time of making of the contract by the agent. Principal should not be non-existent. Friends, take the example of joint stock company. In the formation of joint stock company, there are 4 stages. First is promotion stage, then incorporation stage, then capital raising stage, and the last stage is that of business commencement stage. So in the promotion stage, company is not in existence. Promoters are there. So whatever and contracts they entered into, those cannot be ratified by the company when the company becomes a separate legal entity after incorporation stage. The question is why? Because the company was non-existent at the time when the contract was entered into by the promoters. Coming to the next point, which is the principal must have contractual capacity. The principal must be competent to contract. So contractual capacity is must for the principal. Moving ahead, friends, the act must be capable of ratification. Only the voidable contracts or the valid contracts can be ratified. If any agreement is illegal, say agent has committed the murder of someone, and later on, this act is ratified by the principal, then it cannot be ratified because act is illegal. IPC does not allow for murder of someone. So this act is not capable of being ratified. So ratification will not be valid. Whole transaction must be ratified. See, agent has bought 10 ASIC computers, without the authority of principal. And principal has come to know that he has not authorized him to buy 10 computers. And what principal wants to do? Principal wants to accept 5 and wants to reject the remaining 5. He cannot do like this. So ratification must be done in totality. All 10 computers must be rejected or they should be accepted. So the whole transaction must be ratified. Partial ratification is not at all valid. The principal must have the knowledge of all material facts of the act to be ratified. Nothing should be undisclosed to the principal. Every fact should be disclosed by the agent to the principal. If principal comes to know that something was hidden from him, concealed from him, and then that ratification will not be valid. Ratification must take place within reasonable time. It is not there the contract took place in the month of January, 6 months, the parties are quiet, and then after 6 months the principal wants to ratify this act. He cannot do like this. And what is reasonable time? It depends upon the circumstances of each particular case. We cannot say 1 hour will be the reasonable time or 7 days will be the reasonable time. So what constitutes reasonable time always depends upon the circumstances of each particular case. Ratification should not cause loss to the third party. Say the land is given on lease basis and the lease is terminable by giving 3 months notice. And what agent has done? Agent has given 1 month notice. Now it means giving 1 month notice, for termination of lease will result in loss to the third party. Okay, so friends, here it is third party, okay, instead of property, which I would like to correct. There was typo error here. I would like to correct. So friends, this ratification will not be valid. The act to be ratified must be within the authority of the principal. It must be within the powers of the principal. It should not be ultra-vires, beyond the powers of the principal. If any act to be ratified is beyond the powers of the principal, it is ultra-vires, then that ratification will not be valid. Ratification has a retrospective effect. Ratification comes into existence from the day the contract was entered into and not from the time when it was ratified. That is why we say, friends, ratification has a retrospective effect. Moving ahead, friends, the next one is agency by operation of law. It is a law which operates and the contract of agency comes to an end. As the contract of agency is created. Promoters, in case of a company during the promotion stage, they always act as an agent in case of joint stock company. And another example is, friends, when any person joins the partnership firm, the moment he joins, he becomes the agent of the other partners. Because there is mutual agency element in case of partnership. Each and every person who is partner of the partnership firm is the agent as well as the principal. Being the principal, he is bound by the acts of other partners, and being the agent, he can bind the other partners with his own acts. So in these two cases, it is the law which operates and the contract of agency is created. So friends, I would like to conclude now. There are 4 points regarding creation of agency, 4 ways in which agency may be created. Agency created by express contract, agency created by implied contract, agency by ratification, and the last point is agency by operation of law. Moving ahead, friends, the next heading is extent of authority of agent. The question arises, friends, to what extent the authority can be exercised by the agent? What is the meaning of the term authority? The term authority means capacity of an agent to bind the principal. To what extent, the agent has the authority to bind the principal? The authority of the agent to bind the principal is determined by these 3 points which I am going to discuss. First one is the actual or real authority. This is the authority which is delegated by the principal to his agent. It may be express or implied. That lays down 2 points. The agent having an authority to do an act has the authority to do every lawful thing which is necessary in order to do such act. Whatever is necessary, every lawful thing, the agent has the authority to do. Coming to the next point, an agent having an authority to carry on a business has authority to do every lawful thing which is necessary or which is required for the purpose or usually done in the course of conducting such business. Whatever is legal, okay, in the to be done in the conducting of such business, whatever has to be done or usually is done. Okay, so that much authority the agent will have. And our second point is, friends, ostensible or apparent authority. When a person by his act or statement willfully leads third party to believe that an agent has authority to act on his behalf, the third party acts on the faith of the statement. Such authority of the agent is known as ostensible or apparent authority. Ostensible or apparent means the authority what it appears to the third party. Okay, friends. So this is not real or actual, but it is implied, we can say. Okay, it is the authority what it appears to others. Okay, so take the example of hotel. In hotel, we all find customers must be thinking that this drink and all will be available in the restaurants, and the principal has given the authority to the agent manager not to provide cigars and drinks in this restaurant. But public doesn't know. Public has given the customer has come to the restaurants and he has given the order. Then in that case, friends, this real authority and apparent authority both are different. Apparent authority is what it appears to others. It appears to the customers that when they are going to this hotel, then in that case, cigars and drink will always be available. Okay, so it should be available because the authority has been restricted by the principal, but it has not been disclosed to the third party. So friends, here I have given you the example of apparent authority. Then agent's authority in an emergency. An agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as would be done by a person of ordinary prudence in his own case under similar circumstances. So friends, he should always act in the best interest of his principal. Say some emergency has taken place and agent is trying to contact his principal, but his principal is not being contacted. Then, he should always use his own wisdom, thinking that this act belongs to him. Whatever decision he has to take for himself, the same decision should be taken in the best interest of his principal. So it is foremost duty of the agent. He should always act in the best interest of his principal. And now, friends, hurriedly, I would like to take up this heading, which is delegation of authority. Delegatus non potest delegator. A delegate cannot further delegate. Okay, so delegatus non potest delegator, which means a delegate cannot further delegate. But there are some exceptional cases as per section 190 where a delegate can further delegate. 6 points are here before you. Express consent of the principal, implied consent of the principal, nature of agency, custom of trade, ministerial act, and unforeseen emergencies. You all know, friends, express, term, implied, the nature of agency. There's a custom of trade, okay, and then your ministerial acts or emergency, unexpected emergency has taken place. In all these cases, agent has the authority to delegate his authority. In other words, we can say he can appoint sub-agent. Now, who is sub-agent? Sub-agent is a person who is employed by or acting under the control of original agent in the business of an agency. So this definition has been given under section 191. So friends, here, for sub-agent, agent is the original agent is the principal. But for original agent, principal is the principal. So sub-agent is appointed by the original agent is appointed by the principal. So in such a case, friends, you all know that agent acts in a dual capacity. He is the principal for his agent, but he is the agent for his own principal. There is no privity of contract between the sub-agent and the principal, but there is a privity of contract between the sub-agent and the original agent. So relationship between sub-agent and principal. The relationship between the sub-agent and the principal depends upon whether the sub-agent is properly appointed or improperly appointed. Properly appointed means sub-agent has been appointed in one of those 6 cases which have been laid down under section 190. If he is not appointed in one of those 6 cases, then his appointment is known as improper appointment. What does it mean, friends? Where agent is, sub-agent is properly appointed. An agent is, I told you, friends, how can we say that agent has been appointed properly? Just now I've told you, friends, if agent is properly appointed, then the principal is bound and responsible for the acts of the sub-agent to the third party. The agent is responsible to the principal for the acts of the sub-agent. The sub-agent is responsible for his own acts to the agent and not to the principal. However, in case he is found guilty of fraud or civil wrong, he is directly liable to the principal. Still he is liable because his appointment is proper appointment. Okay, and now when sub-agent is improperly appointed, what are the consequences of this? Friends, the principal is not represented by the sub-agent, and he is not responsible for the acts of the sub-agent to the third party. The agent is responsible for the acts of the sub-agent to the principal as well as to the third party. The sub-agent is not responsible to the principal even for frauds or willful fraud. So friends, you know that consequences are different in both the cases. Where sub-agent is properly appointed, where sub-agent is improperly appointed. So friends, I have covered number of headings. Now, what is this substituted agent? Where an agent holding an express or implied authority to name another person to act for the principal in the business of the agency has named another person accordingly. Such person is not sub-agent but an agent of the principal for such part of the business of the agency as entrusted to him. So friends, the term substituted agent has been defined under section 190. See, principal has given the authority to the agent, either express or implied. And accordingly, agent has given the name of someone and that he said, okay, this person will act as an agent of you. Then that person whose name has been given by the original agent will be known as substituted agent. He will not be known as sub-agent. So does a substituted agent is the agent of the principal, but not of the agent. He is directly responsible to the principal and privity of contract is established between the principal and the substituted agent. Okay friends, so you must understand substituted agent is different from sub-agent. So in my next video, friends, I'll take up the distinction and then whatever other headings are left out, that I will cover in my next video. So in this video, what all headings have covered? Started from the heading Contract of Agency. They talk about 2 principles upon which Contract of Agency is based. Then I talked about features of Contract of Agency. After that, I did talk about kinds of agents or classification of agents. And then how the Contract of Agency can be created. After that, to what extent the authority can be exercised by the agent. After that, I took up the heading which was Delegation of Authority. Delegators, non-potest delegator. A delegate cannot further delegate. And in this context, I talked about sub-agent and substituted agent. Friends, it is all about this video class. I hope you will like the content. Do subscribe to my channel if you are not subscribed yet. Do press on the bell icon, to get notifications of my subsequent videos. Keep smiling and stay blessed always. Okay, friends, we'll meet soon. Goodbye.